Welcome to Advocating for Dads with Jana Jones.
Welcome back to Advocating for Dads with Jana K. Jones. Jana is a North Carolina family law attorney based in Charlotte. She's spent over 15 years helping fathers navigate custody disputes with clarity and preparation. I'm Lisa Mosby, your host, and today we're addressing a common and urgent question. Can a mother legally deny visitation in North Carolina, and what options are available if that happens? Welcome, Jana. Thanks for joining me again today.
Hey, Lisa, great to see you.
Yeah, under a valid North Carolina custody order, does one parent have the authority to withhold visitation from the other?
Not unless it's explicitly stated in the order. So, for instance, if mom has an order that says she has sole physical and legal custody of the minor child or children, then that means she has the discretion to decide when and if the child or children get to see the other parent. So if you have an order like that, then the answer is yes. Outside of that, if there's an order that talks about the amount of time that the child or children spend with each parent, then no. She's going to be potentially facing a contempt if she withholds the child when that time for the father, presumably, is supposed to happen and she's not allowing it to happen.
And are there any circumstances where denying visitation might be legally justified?
Sure. So, if dad has visitation, in this example, and dad hurts the child in some type of way, no court is going to have an issue with mom being protective of their child. Now, what I would recommend in that circumstance, depending on what their custody arrangement is it might be appropriate to file an emergency custody action in that scenario. In order to kind of not only protect yourself from potential contempts, but also get the court alerted as to what's going on. But outside of that, if the parents just don't get along, they're mad at each other, etc., that's not going to be a basis to withhold the child and not allow the court-ordered visitation to happen.
And if a parent believes the child is not safe during visitation, what is the proper legal route instead of just withholding time? You kind of led to it, but let's go a little bit deeper.
Yeah, so if you feel like the other parent is posing some type of risk or harm to your child, then filing an emergency custody action is going to be important. That's a basis for emergency custody. And in that scenario, generally speaking, the court is going to read the pleadings and determine if they think that there is enough there to grant you an order that may give you sole physical and legal custody. But what will also happen is there will be a review hearing so that the court can hear from both sides, because obviously they've only heard from one side at that point. And so at that review hearing, the court will then determine whether or not there is still an emergency basis and that emergency order needs to be extended in some capacity, or whether or not it needs to be dismissed because maybe there wasn't an emergency, and the parties would then revert back to their original custody order.
So, Jana, what happens if a mother repeatedly refuses to comply with a visitation schedule?
So your options are a couple. When you have a court order, law enforcement has the power to effectuate that order. So you could call law enforcement and say, hey, I've got an order. We're supposed to exchange the child. I'm showing up to the house. She won't come out the door. She won't let the child come, etc. And the police could come and they could say, this is his custodial time. You need to give us the child so that he can get his custodial time. That is the power of the order. The other option that parent has is to file a motion for contempt, against that parent, alleging that they have violated a provision of the court order and they're asking for the parent to be punished based on that willful violation.
How do courts in Mecklenburg County respond to documented patterns of interference?
They don't like it.
No.
The judge does not like it. Not at all. And what can happen as far as punishment is concerned with contempt is you can go to jail for violation of a court's order. And so if that's a repeated pattern, that is a very real possibility that the court has in their arsenal and will be willing to use it for people who are being kind of egregious with the amount of withholding that they're doing.
And then can denied visitation impact future custody decisions?
It can. It can. If the court feels like maybe there's a custody arrangement where there was joint custody and one parent is just completely withholding the child from the other, the court may feel like, based on that parent not doing what's in the child's best interest, not following the court's order, that maybe it's not going to be in that child's best interest that they spend as much time with that parent. So maybe now they're getting shifted to a visitation schedule. But in order for the court to change an order, there has to be a modification filed by one of the parents. So if you file a motion for contempt because, let's say in the scenario, mom doesn't let you get your child or children, the court will punish her potentially for violation of that order, but they will not change the order based on a motion for contempt. You must file a motion to modify for the court to be able to change the order. And then if you file a motion to modify, you have to allege a substantial change in circumstances since the entry of that first order. If you can't meet that burden, then the court is going to be unable to make a best interest determination and potentially change the custody arrangement.
Let's tie this together for folks. Without sharing any confidential details, can you describe a situation where a father faced a repeated denial of visitation and explain how the court ultimately addressed it?
Yeah, so I had a situation where there was a father who was denied time with a very small child, infant child. And the court, because of that, decided that they were going to implement a joint custody arrangement. And the parent had had very little time with that child, but the court found that they were appropriate, had the appropriate housing and, work related childcare set up and all the things that are needed in order to parent a small child. And even though they had very little contact with that child, the court ended up granting joint custody.
And then what documentation should fathers maintain if parenting time is being interfered with?
So definitely keep a calendar. If you have a court order that says when you're supposed to get your child, get a 12-month planner, highlight it, know when you're supposed to get your child. And if you are not allowed to get your child during that time, mark it down. Because when you file your contempt, you're going to need to allege specific dates that you're saying that the child was withheld from you. And those must be dates that were in the court order where you were supposed to have your child. So, for instance, if you're supposed to have every other weekend, mark those weekends down. And if you don't get your weekends, then keep track of that. And once you're ready to file a contempt, you want to allege each and every weekend that you are not allowed to get your child.
Before we move on, something's bothered me. It's like speaking in my head. I want to go back to circumstances where denying visitation might be legally justified. If a child is sick, can you keep them home and not send them to the other parent? Or the other one that came to mind is vacations. Do you have to approve your vacation with your significant other before you can schedule it so that you could take your child with you? Or would that, if you just schedule it and take the child with you, are you denying visitation and can you get into legal trouble with that?
Yeah, so I would say to your first point, if the child is sick, can I withhold the child? If you have an agreement with the other parent, sure. And I would make sure you get that in writing, ideally an email, saying, "Hey, Johnny's sick. I'm going to keep him this weekend if that's okay with you," and hopefully get a response back. Sure, that's fine. Outside of that, though, the fact that the child is sick doesn't mean one parent is more capable of caring for the child than the other. So that on its face and on its own would not be enough to kind of justify that. I would say unless it's a situation where the child is so sick they can't move, right? They can't get out of the bed, then obviously that's a different scenario. But if you're talking about a common cold, anybody can treat a cold. Mom, dad, grandma, grandpa, anybody can treat a cold. So that's not going to be a reason. To your other question about vacation, things like that. Generally speaking, in Mecklenburg County, the most common thing we do as far as like summer, because we are on a 9-month school year for CMS, is that each parent is entitled to 2 non-consecutive weeks in the summer. And so what that means is you've got 2 weeks of vacation with your child. They can't be taken back to back, so it can't be 2 weeks at a time, but you do get 2 weeks, and each parent gets that. And generally speaking, there's some kind of tiebreaker language if there is a conflict. So if both parents are wanting to take the child out of town or for vacation for, say, the 4th of July, then there may be some language in there that says if there's a discrepancy, parent one gets even years, parent two gets odd years as far as who gets to trump the other. So in that scenario, maybe parent one gets the 4th of July that year, parent two gets the 4th of July the next year, right? But there has to be an order. So if there is not an order in place, then it's a free for all, frankly. So you're not going to be kidnapping your own child to go to, the Bahamas on a cruise. So you're going to be able to pull that off, assuming the other parent doesn't keep the child with them and make it impossible for you to do that.
The other one that comes to mind is, what if your child wants to go to horse camp or Girl Scout or Boy Scout camp or church camp? Who does that affect? Does that come out of one side or the other's side visitation, or is that neutral territory? How does that work?
So, generally speaking, that's kind of a quasi extracurricular activity. And so, if that is something that the parents are typically disputing with each other, they can't come to an agreement about, then the parent who has final decision making authority on extracurriculars is likely going to be the ones to make the call on that. But assuming both parents agree that the child should go to, whatever camp in the summer, then it's really not anybody's time per se. They're, at the camp. I would say that, let's say you've got a scenario where one parent has the child the majority of the time, maybe during the school year, and the other parent gets the child in the summer because they're so far away. So I'll say, the child's in North Carolina, the other parent is in, say, Florida. And so they're using the summertime to make up time with their child. And the parent in North Carolina says, "Hey, I want to put them in camp for this summer." Well, now you're affecting the other parent's custodial time. And if that parent doesn't agree with that, then no, you're not going to be able to pull that off.
Makes sense. For fathers experiencing visitation problems, when does it become necessary to file for enforcement or contempt? That's where we're going to wrap it up today.
So I would say it depends. And the first thing that you want to do is get legal counsel to figure out your best strategy, right? Because if it's something that's recurring, you may want to kind of wait till you've got a good number of them to kind of piss the judge off enough, frankly, to want to really do something about it. Because I tell people contempt is kind of a vicious cycle. You can get held in contempt, generally speaking, the first time around, no matter how mad the judge is at what you've done, they're probably not going to put you in jail. And then you're coming back around on the same things. And for the parent who is the one asking that the other parent be held in contempt, it can be a very frustrating process because they don't feel like that parent is really being punished, right? Because they're kind of able to weasel out of going to jail, or maybe they get a suspended sentence, or they get on unsupervised probation for a year. And none of that really feels like you've gotten any victory or your day in court. So knowing that, I think it's important to have as much evidence as possible. So if you're, the non-custodial parent, you're supposed to get every other weekend. One weekend gets missed, write it down on your calendar, but I wouldn't run to the courthouse and file over one weekend. Not unless it was something important, like maybe you were getting married that weekend, right? That's going to be important. But if it's just an average weekend, she didn't let you get the kids, I would wait until there's a few of those weekends and then file, because then it's showing a pattern as opposed to you going to the court every single time it happens.
And I know I said that was going to be the last question, but I do have one more. If there are fathers out there who do not have legal representation or are dissatisfied with their legal representation because things are not moving in the direction that they feel is right for their child, how do they connect with you? What do you want them to know on how you can assist them in their process?
Sure. So we're on all the socials, but the easiest thing to do is to give the office a call, 704-275-3505. The first step is always a consultation. So my team will be able to set them up with a consultation so we can talk through all of the things that they're frustrated about, all the things that they're wanting to see happen in the future. And I'm a very straight shooter. I'm going to give you my realistic thoughts on expectations and things of that nature. I feel like relationships with your attorneys is kind of like a relationship with any other professional, your tax preparer, your doctor, etc. You need to feel comfortable with the person that you're with, and you need to feel like you've been heard, and that they're representing your interest. And so if you do not feel that way, then there is nothing wrong with seeking, kind of a second opinion to see if this is the right fit for you. And if it's not the right fit, it may be time to make a change.
Jana, as always, thank you so much for your insights. I'm a huge fan and admirer of yours because you are one sharp lady and know your stuff. And so thank you for inviting those in to your world that may be struggling in this area. Folks, that's a wrap up for today's episode of Advocating for Dads. If you're dealing with repeated interference or uncertainty about your options under North Carolina law, you can visit of jkj.com to schedule a consultation with Jana and her team. Thanks so much for listening, and be sure to subscribe, leave a review, and share this episode with a North Carolina dad who may need the information. And we'll see you next time.
Thanks for watching. If you like this video, don't forget to hit that like button and subscribe to our channel for more amazing videos like this one.